Hello friends, this video is on how to approach the multiple choice question in UPSC prelims. We are doing the questions on Indian polity. We'll discuss some methodologies to tackle the question successfully, effectively. There are 5 questions which we will be discussing to tell you how to crack the questions. Come to the first question. See, this question is testing the concept clarity. The question is on the definition of state. The question says which best defines the term state, which means that there are many definitions of state, but the best definition of state you have to identify. State means what? We know the concept of state means 3 things. What? Number 1, it should have population. Number 2, it should have a territory. State is a territorial unit. And thirdly, there should be administration, that is government. If these 3 things are present, then it should be called a state. So, in these choices, you see where these 3 things alone will be present to be called a state. If you look at this first statement, a community of persons permanently occupying a territory is there, independent of the external control and possessing an organized government. So, 2 things are there. One is the territory and administration is there. Now come to the second choice, politically organized and persons also. So population, all the 3 are there in the first statement. A community of person, that is population, territory, and there is a government for administration. So all the 3 are present in the first statement itself. But don't come to a conclusion that A is the best answer. Read B, read C, read D. After reading all the choices only, you have to finalize the answer. So, though we know all the 3 are present in A, we'll have to read B. A politically organized people, so population, territory, and authority to govern, government. But there are certain extra fittings they have given to this, definition called maintain law and order, protect their natural rights, safeguard the sustenance. So extra things are there. Okay, now come to C, persons, territory, culture, whether any culture, all these things are there. Culture related things are there in the definition of the state, no. But here what is written? Culture. So in B, you have something extra than this population, territory, administration. In C also you have extra than these 3 things. Read D, a society permanently living in a territory. Government. So territory is there, government is there. Then what? Judiciary. Territory is there, government is there, judiciary, independent judiciary. So this is another extra fitting. And now come to a conclusion. 3 things should be there for state. These are the 3 things. So the best definition given for the first question is present in A choice. So A is the best answer. Conceptual clarity you have. If you have, then there is no problem in identifying the right answer, right? Now come to the second question. The second question is comparison question. Comparison of Indian constitution with the world constitution is not explicitly mentioned in prelim syllabus. It is explicitly given in the main syllabus. Comparison of Indian constitution with the world constitution. World constitution means what? Most of the provisions of Indian constitution we have taken from the British system. For example, 250 provisions of Indian constitution have been directly lifted from Government of India Act 1935. So, it is natural that they will compare the system of British with that of India. Which system we have adopted from British? Parliamentary system. So parliamentary democracy is the question. How parliamentary democracy differs in these 2 countries is the question. Read the first statement. As regards legislation, British Parliament is sovereign. Indian Parliament is not sovereign. British Parliament is sovereign. So you know that this is right. In matters related to constitutionality of the amendment of Parliamentary Act, it is referred to the Constitution bench by the Supreme Court of India. Yes, this is also true. If there is a constitutionality, that is what is questioned with respect to a parliamentary act, it will be referred to the full bench or the constitutional bench. So, both these statements are correct statements and the answer is C. Now, in the first question, it was conceptual clarity which is tested. In the second question, comparison of constitutions was tested. Now, come to the third question. Now, this question, there is no topic called judicial custody and all. in the popular books which you have referred. It is not explicitly given in Lakshmikant or in the NCERT books. You have to just read the question without getting a shock. Don't get any shock, right? What is judicial custody? From the term itself, you can know that it is the custody by judiciary. Who and all can take you under custody? Judiciary can take you under custody. Police can take you under custody. If police is taking under custody, they'll keep you in police station. If judiciary is taking you under custody, you will be kept in jail. Okay, this is very, very common sense. This is very, very common sense that by seeing this question on judicial custody, you should not get fear that I have not seen something connected to judicial custody, so I don't know. This mindset, negative mindset should not be there. This is not an alien question. It is a very, very commonsensical question which you come across in the daily newspaper. So never ever get worried by seeing a word or a term which is not there in the standard book. Don't assume that something I have not read, I will not be able to attack. You can easily attack the question because it is very, very generic type of question which does not require any constitutional knowledge and all. If you put this question to your father or your brother or your sister, they will be able to identify the answer. So the mindset should be that this is an easy question. It's a very common generic question. I can solve the question. If you have this mindset, automatically you will be able to get the correct answer. What judicial custody means? Custody of the concerned person under the custody of the concerned magistrate. Okay. Accused is locked up in the police station, not in jail. We told if you are locked up in police station, it is called as police custody. If you are put in jail only, it is called as judicial custody. So the first part is right, but the second part is wrong. That you are locked up, the accused is locked up in jail, not in police station. So second part of the question is wrong, and therefore even though the first part is right, second is wrong. So first statement is wrong. Judicial custody. Police officer is not allowed to interrogate the suspect without the approval of the court. This is very common sense. If somebody is under judicial custody, judiciary will have to permit the interrogation to be done by the officer. Otherwise, the interrogation cannot be done by the officer. So this is a very, very logical, commonsensical question, and therefore the answer is what? 1 is wrong, 2 only, 2 is the right answer. So first question, conceptual clarity. Second question, comparison of Indian Constitution with world constitution, that is British Constitution, and third question is on common sense, right? Common sense will be tested, which will not be there in the standard textbook. Fourth question, read this. This may shock you. You know the Contempt of Court Act, but what fact you do not know? On whose recommendation this act was passed by the Parliament? Nowhere it is given. Nowhere it is given. In the standard book it is not given. Don't get worried, because the question here is not testing the unknown facts. Even without knowing a fact, this is not a test of your fact, this is a test of elimination. It is only a test of elimination, that you don't know this statement, leave it. Go to the second statement. Constitution empowers Supreme Court and High Court to punish for contempt of themselves. Yes, you have studied very well in the Constitution that it is a court of record. Both Supreme Court and High Court are court of records. They can punish for contempt. So this is a constitutionally correct statement which you know, everybody knows who read the Constitution. Constitution defines civil contempt and criminal contempt. If Constitution has defined this, why there should be a law? Tell me. If there is a definition in the Constitution, there is no need for a law at all. Since there is no definition in the Constitution of what is civil or criminal contempt, you have to make a law. So Constitution did not define, law only defines. Parliament is vested with the power to make law. That is why Contempt of Court Act was made in 1971 by the Parliament. So is vested with the power to make law. 4 is right. Now using these two choices, what choices? 3 should not come, 4 should come. 3 should not come, 4 should come. But here 3 should not come, 4 should come. Which is the choice where 4 is present, 3 is not present? This is the choice. So which means that I do not know the first statement, but still through elimination technique I am able to identify the right answer. So now also when you see, they are psychologically they are testing you according to me. If they have put this statement in the last, you will not have any fear. If this statement is put in the last, you will not have any fear. They have put that in the first statement fully knowing that no one or majority do not know which committee recommended the passage of this act. So psychologically they are testing you. Don't worry, patiently read the question, have cool headedness. When you handle the paper, you will get the answer. So this question you can easily solve through just elimination technique. It is not a test of fact. Now come to the fifth question. Anti-defection law. You have read anti-defection law. You have read the 10th schedule. But what is tested here is, have you read carefully or not? Have you read with very much due focus on the statement? That is what is tested. So, are you careful in reading? When you become an IAS officer, you should read each and everything carefully. Otherwise, it will be a mistake on your part. So, read this first statement. Law specifies that a nominated legislator cannot join a political party within 6 months. He can join a political party within 6 months. When you read that cannot, within, before, that wordings are you reading carefully. Change of the word means change of the meaning or change of the fact itself. So, instead of can, they have put cannot. But your mind will be tuned to read in a particular way. You have to be very careful. Whether can is written or cannot is written, you should be very careful. You should be a very careful reader of your constitution, of the statements given in the question. That is what is tested. Nothing more than that. Go to the second statement. Law does not provide any time frame within which, yes, is there any time period within which the presiding officer will have to pronounce his decision regarding disqualification under anti-defection law? No such a time frame is given. That everybody will know. So, everybody will know this, but here when you read, you will have to be very, very careful. Answer therefore is 2 only. So, 5 questions we have taken as a model question. These 5 questions I have taken from 2022 polity paper and 2021 polity questions to tell you that there are 5 dimensions. Which are the 5 dimensions? In the first question, we have seen about the need for conceptual clarity, and in the second question, we have seen comparison, then we have seen common sense, then we have seen what? The carefulness, and in the state question, in the question on state or application, we have seen the application part of the concept. So, these are the 5 questions which we have taken up, and we have told you how to approach the question. This is the approach. Much more questions will come from other subjects by the expert teachers of our institution to give you a better understanding of how to crack this UPSC prelims examination. Revising for UPSC examination is really a very challenging task, because whatever you have read in the last 1 year or 2 years or 3 years has to be consolidated, because revision is the surest way to clear the examination. First revision is a very, very challenging task, and we have taken that task to ourselves. We, the team of teachers, will comprehensively consolidate your prelims preparation through our crash course. This crash course is going to start on 7th of March 2023. It will be 65 hours of crash course. In that, 50 hours of crash course will be for general studies and 15 hours of crash course will be for CSAT. In that 50 hours of crash course for general studies, 10 hours of crash course will be for Indian polity. In 10 hours, I will complete Indian polity, which will be definitely giving you an edge in the UPSC Civil Services Prelims Examination 2023. Thank you.